Bigfoot is taking his free speech fight to New Hampshire's High Court today.
Bigfoot is really an amateur filmmaker, and he claims he was prevented from filming in a state park. And our Lauren Collins has the story, joins us live now from Manchester. So, Lauren, we can say there was a Bigfoot sighting at the Supreme Court today.
There absolutely was. And you know, when you hear about this story, it makes you chuckle. But it does bring up a very legitimate discussion about balancing the freedoms of artistic expression and speech against public safety.
Justice will prevail.
Bigfoot wasn't allowed into New Hampshire Supreme Court Thursday. Filmmaker Jonathan Doyle had to shed his creative persona as 5 justices considered whether the state had violated his First Amendment right.
If the state can regulate his activity, which is protected by the First Amendment, then the state can regulate all First Amendment activity.
It was September 2009 when Doyle and several friends went up Mount Monadnock dressed in costume to approach unsuspecting hikers in a mock documentary about the mythical beast. Production wrapped unexpectedly when the crew was kicked out of the park. Rangers explained Doyle needed a $100 permit, filed 30 days in advance, and a $2 million insurance rider before he could carry out a production on the mountain. The ACLU, which sued on Doyle's behalf, says that rule is selectively applied and stifles artistic expression.
If Lady Gaga wants to put a concert on up there that's free, doesn't she have to get a permit?
I would say Lady Gaga does, because...
Well, what's the difference? She's an artist.
Doyle never filed for that permit.
It just never occurred to me that I would have to go get a permit.
Probably because he'd been up there before, as countless other artists have, without incident. The state says the permit policy is in place and was enforced in this case for safety reasons. But Doyle suspects park rangers were just annoyed by his gimmick.
Well, Your Honor, again, it's not the having a costume is not what's determined.
Of course it is. That's exactly what this case is turning around.
One of the justices brought up an interesting point about this policy. If a presidential candidate wanted to hold an impromptu speech at the mountain in response to something that had been said the day before, they wouldn't be able to do that within the 30-day window that's required and the insurance steps to take. So a very interesting discussion on many, many levels. Doyle says he just wants to be able to go back to the mountain and finish his film. A judgment is expected within the next 180 days. Latoya?
Lady Gaga even made it into the discussion. All right, Lauren Collins, thanks so much.